Having 25 years or so experience as a lawyer, I thought it would be interesting to approach the topic of internal disputes and conflicts in charities as if I were a medic. So I'm going to try to offer in the next few minutes some thoughts on the diagnosis, the treatment, and the prevention of internal conflicts in charities. Starting with diagnosis. Well, there are two ways you can diagnose any sort of problem, I suppose, and in particular, an internal dispute in a charity. You can look at the form of the dispute. What does it present as? Bottom right-hand corner, the boy must have measles. He's got red spots, we think. We just look at the surface symptoms. And then, so in our pathology of charity disputes, we can see different types of formal disputes. Staff arguing with trustees. That's one way in which the dispute might present. Trustees arguing with each other might be another example. Members falling out with the trustees, fairly common. Members falling out with each other, equally common. And underlying all of this, there'll often be questions about conflicts of interest and conflicts of loyalty, which to my mind are absolutely crucial in trying to understand not just what you see in the dispute, but what's really going on underneath. Of course, one type of dispute can shade into another. The chief executive may fall out with the chair, and then the trustees splinter to who takes which side in the argument. But the thing I want to encourage us to think about is not just how the dispute presents itself. Usually a dispute between staff and the board will result typically in the staff member leaving and being paid some money. That's relatively simple. But once it spills into something else, it can become much, much more difficult to solve. Conflicts of interest, where a trustee typically could be a member, has a personal interest, sometimes a financial interest, not necessarily so, which conflicts with their duty to the charity. Most of us will recognise those. Most of us will feel it. Our conscience is pricked. We think, well, it's probably not appropriate for me to be involved in this decision because it's about whether to, employ my wife's firm or whether one has a sense that there's something wrong. Most people do. Not everybody, but most people. Conflicts of loyalty are actually much more difficult, and I think probably account for quite a lot of the intractable problems one sees in charity disputes. It's because not only does someone not realise they may not be acting in the best interests of the charity, they think they're doing the right thing. In fact, they're convinced they're doing the right thing. Their conscience isn't pricked in the way in which it might be when their personal interest is engaged. Because, to take an example, they may be on the board of the national charity and they've been sent by a local region. They see their role as to champion the interests and the cause of the local group that sent them to be a trustee of the national board. And so far from realising that they're actually making life difficult for the national organisation, they feel that they are doing the right thing. They feel righteous in their pursuit of a sectional interest rather than the charity-wide interest. And that's, I think, a thing that sometimes in our guidance, the regulatory guidance, tends to emphasise the problems, the obvious problems with conflicts of interest, but sometimes tend to look less critically on conflicts of loyalty, where there are conflicting duties or where someone's got a slightly misplaced sense of loyalty. And the reason it gets so difficult is because it's very hard then to stop somebody. If you can buy off a member of staff who's got a complaint, you can't buy off a trustee. Come back to that in a moment. Can you buy off a trustee? But most of them don't want to be bought off. They want to be vindicated. And of course, in large numbers of internal charity disputes, certainly the ones I see, there'll be membership charities and there'll be religious membership charities. So not only have the competing sides got a conception that what they are doing is the right way of pursuing the cause, they probably think they've got a divine approval of their position, which makes it quite hard to settle at mediation as well. But on top of all of that, there's no one talking back to them. And I find it quite helpful to think in terms of a concept that was coined by Anna Freud, the daughter of Sigmund Freud, in her book in the 1940s, on the forms of defense. She's talking about different ways in which we sort of psychologically defend ourselves against things. And her particular contribution, often regarded as one of her one or two sort of original contributions to psychoanalysis, is the concept of altruistic surrender. And she gives the example, a very sort of, a Freud type of example from sort of fantasy Vienna, of the governess who is sort of very timid, wouldn't say boo to a goose, but when it comes to pursuing the interests of the children she's looking after, she's absolutely aggressive, and nobody can stand in her way. You can think, and one thinks the same way as a parent. Sometimes you wouldn't dare to force your way to the front of the queue if you were just standing there by yourself. But when you've got complaining children and something else, then suddenly the sharp elbows come out, and you can persuade yourself to behave in a rather more confrontational, aggressive way because you're doing it for somebody else. That's justified in your mind. Doing it for yourself would be appalling behavior. Doing it for somebody else, well, that now becomes justifiable. And that, in real life, sometimes one's children say, yeah, stop it, you're just embarrassing us now, Dad. The problem in a charity is there aren't any real life people often. There's a conception of a cause. There's an idea of what you're there to pursue. And it doesn't talk back. It really just becomes a mirror of what you're thinking. So trying to understand the psychology of what's going on underneath, I think, is important, not just looking at the form of the dispute. Of course, sometimes it will be quite simple to look underneath at the substance. So you can have a dispute where it simply is a dispute about a legal question. So I had a case a few years ago about the Greek Orthodox Cathedral in London. And there were two sides to the argument. And in 1865, this charity had been founded originally as a burial ground. They bought a plot of land in west of London to bury Greek Orthodox people when they died. Their charitable objects were the interment of Greek Orthodox Christians. My solicitors seemed to have a sort of mental block because every time they typed it out, they wrote the internment of Greek Orthodox Christians, which is not a charitable purpose. Anyway, they expanded, they had another burial ground, and then they bought a church site. And they executed a new trust deed in 1935 that purported to broaden their purposes to include various other things. And the simple dispute was what they were going to do with some surplus cash they now had from selling off burial plots. And it depended whether the 1865 deed was the only document that governed them, or whether the 1935 deed was effective as a matter of law. Pure legal question. So in the end, it had to be resolved by a court. There's not really much point in having a mediation when that's the issue. You could spend a lot of time and money, but somebody just needs to decide it, and everyone just needs to move on. They could perfectly well get on with each other, they just had a difference of view. So that's an example of a sort of pure legal question. Sometimes it's clear that you've got the legal power to do something, but the question is whether it's a good idea to do something, a sort of strategic difference. So an example of that might be the dispute that the Children's Investment Foundation Fund had a few years ago. So you remember this was the spin-off of the sort of what was then, possibly still is, the biggest divorce case ever in England and Wales, with Chris Hone, who was an investment fund manager. He'd made lots of money. He and his wife Jamie got divorced. There was a big divorce settlement, but actually they had even more money in the charitable foundation they'd set up that he'd run, and it was worth billions. And the question was, were they, as part of the sort of side deal with the divorce, she was going to leave the board of the charity, and the charity was going to help fund set up a new charity that she was going to run. And then there was disagreement as to whether that was the right way for the original charity to apply its funds. So that's an example where it's not really a question about whether you can do it, it's a question whether it's the right thing to do. And then people have to try, if they want to challenge it in the courts, they have to try and generate a legal principle or a legal point to argue about. And in this case, it went all the way to the Supreme Court, and it established the proposition that not just the directors of a charitable company, but also the members of a charitable company owe fiduciary duties in the way they exercise their powers. And that was a case where 10 years before it got to the Supreme Court, it could just have stopped if someone had said, well, I don't care, I'm going to resign, I'm not going to be involved in this charity anymore. But because there was a dispute about strategy in the future, people sort of engineered legal points. So it looked like a case about a legal point, but it's really about a divorce. That's what it's really about. Personality clashes, similar to what we've just discussed, they often arise in charity contexts with arguments about what happened at an election, or what happened at a meeting, and whether the meeting was properly run, whether the election was properly run. Again, the question that might appear on the face of the documents when I get it as a lawyer might be, what does this rule of the Constitution mean? That's how people have managed to position their argument in sort of legal terms, but it's not really about that at all. What it's really about is whether Mr. So-and-so or Mrs. So-and-so should get to be president this year of the organisation. And that can matter for some people. Sometimes it's linked to self-esteem, sometimes it's linked to a particular agenda they have. In England and Wales, a lot of the membership disputes we see in a religious context will be amongst emigre communities. So often there'll be a status importance attached to being the chairman of the mosque or the president of the Gurdwara or whatever it might be, that perhaps wouldn't be true in other communities, because perhaps back home you may have been in a particular position of some social standing, high social standing, and you don't have that in the same way. And so having this particular position in the charity which represents your community becomes much more important. And sometimes these disputes reflect sort of political or even geopolitical disputes. Again, I can say all this because it's all in the law reports. There was a dispute at the Ethiopian Orthodox Church in London a few years ago. And the legal issue, as it presented, was, did the reference in the trust deed to the patriarch mean the man who sat in the Holy See in Addis Ababa, or did it mean the man who used to do that job before he was forced to flee to Seattle by the new government at the end of the civil war in Ethiopia? Now, but it's not really about the meaning of the trust deed. It's really about whether you backed that particular regime in Ethiopia or the opposition regime. So trying to understand what's really going on is sometimes needs to go a bit below the surface in order to work out what the best treatment might be. And broadly speaking, I think there are these. There is self-medication, there is mediation, arbitration, and there is litigation. But the point is, there does have to be a treatment. And you often see that pious words often come from our regulators about the importance of avoiding litigation, it being a waste of the charity's resources, which is all true. But if you have an intractable dispute, it has to be solved somehow. And my personal experience in England and Wales is that the reluctance of the regulator to let people start litigation sometimes doesn't entirely grapple with the, well, how else are we going to bring this dispute to an end question? Because there comes a point at which people cannot get on in the way you might hope them to. And unless you're going to leave them to it with baseball bats in the car park of the temple on a Saturday night, it's probably better to let a court decide the question. So one does need some sort of treatment. Self-medication probably takes the form of some kind of settlement agreement. So self-medication is probably going to be the most suitable solution to a staff and trustee dispute. Usually that can be settled. If there's a trustee who's misbehaved, they can probably be persuaded to go and resign. If a staff member's being difficult, or if the trustee won't go, there might be some sort of settlement agreement, some money changes hands perhaps, and the member of staff will leave and go on to do something else. It's obviously not always that simple, because obviously lots of people who are working in the sector are not really working because of the financial rewards, they're working because they're devoted to the cause in the same way the trustees who are volunteering. But self-medication is most likely to work in that sort of circumstance. The question that will often arise is, how far can you go in compromising a claim before really you're just giving away more than the claim is worth, and it becomes something much more like an ex gratia sort of payment. And obviously, increasingly, there's controversy around the use of NDAs and confidentiality agreements, which have a perfectly legitimate place, rightly used, and will almost invariably have a sort of whistleblowing get out anyway. But that's something for charities increasingly to be sensitive to, balancing effectively the competing reputational risks of not trying to silence the dissentient on the one hand versus appearing aggressive in the overuse of NDAs on the other hand. And if you can't sort it out just in a sort of an exchange of correspondence doing a deal, then getting somebody involved who's either from a national umbrella body, a respected figure in the community, possibly a regulator, somebody else to act as some sort of informal mediator might help to come to an arrangement. Mediation, much vaunted, always recommended, and successful more times in my experience than it is not, except when it's being imposed on the parties by a regulator who's refusing to let them go to court until they've tried it, where sometimes we just find we're going through the motions because what everyone really wants to do is get into court, and the only way to get into court is to tell the regulator you've had a failed mediation, which is a bit of a waste of time. So a mediation that's too early can be a problem. One of the things. There is something about timing a mediation. There is nothing like the week before the trial is due to start and you're being told by your lawyers we need this many thousands on account now if we're going to do it, and you need to book next week off work because you're giving evidence to focus people's minds. Mediating at that sort of stage tends to be more effective than mediating before anybody's yet felt any pain. But obviously costs have been incurred the later you leave it. A point that often comes up in a mediation is who's got authority to agree. To the inexperienced, one thinks one's got a deal late in the afternoon, only then to find that the people in the other room are in fact only 3 of the 7 trustees, and they haven't actually got authority from the other 4 trustees to agree on these terms, and they can't get hold of 2 of them, and one of them's on holiday, and so on and so forth. So making sure in advance that those who are going to be present have authority to come to a binding agreement is good advice. And working out how people who are not formally party to a dispute might be bound is also quite important. You sometimes get the situation where one group of members have a complaint, another group of members oppose them. Those people settle their differences only for somebody else to pop up over here and rerun effectively the same argument. So trying to find ways of binding people in is important. People often try and make their mediation agreements conditional on consent from the regulator. Sometimes that's required because you're doing something that requires a regulatory consent. But if you're just putting it in the agreement because you're not convinced whether or not it's a very good deal and you're hoping the regulator will tell you, certainly in England and Wales, you should expect fairly short shrift from doing that, and they'll tell you to make your own decision. So it's usually a recipe for problems further down the road if you do a deal but make it conditional on commission consent where commission consent is not formally required. And costs is always a sticking point. About 16 years ago, I was instructor for the Attorney General in the days when the Attorney General in England and Wales was more actively involved in charity cases than would be true of the last 10 years. And it was a Gurdwara dispute, so a Sikh temple dispute. And it's memorable because the mediator was Cherie Blair, and it was just after Blair, about 18 months after Tony Blair had stepped down as Prime Minister. It was perfectly obvious to me, sitting in a room on my own, representing the Attorney General, that the only reason a deal was being done was because everybody was in awe of the mediator and wanted a selfie with her at the end of the day. And the sticking point was cost. Everybody was happy to do the deal, provided the charity paid everybody's costs. And we were talking hundreds of thousands across several different disparate groups. And I sat there representing the Attorney General, refusing to let the charity's money be spent, certainly on paying all of everybody's costs. And that became the sticking point. So by the end, everybody who hated me, including the mediator, trying to bully me into, and a deal was done that was ambiguous. And I remember, had the conversation at the time, this is a problem. And sure enough, within about 3 months, the deal fell apart. And because there was an ambiguity, deliberate ambiguity, in order to get the deal about who would pay a certain section of the costs, there was then a further round of litigation about who would pay the costs of the first round of litigation. But it's an unfortunate feature of the landscape in England and Wales that the Attorney General has withdrawn. I mean, no doubt because there are serious resource constraints affecting the Attorney General's ability to participate in every religious membership dispute that goes on in England and Wales. But it is an unfortunate feature of that withdrawal that there is now no one who has solely the charity's interests at heart when you're trying to settle a dispute, when most of the people who are parties to it now have some interest, even if it's only getting some of their costs back, that influences the terms of the deal. Yes. Mediations. The great thing about mediation is you can do more than the court can do. You're not limited to the powers of the court. Arbitration. Less common, perhaps most commonly seen in the religious context. The picture in the bottom right-hand corner is a 19th century painting of the Beth Din of America. So a Beth Din is, to a lawyer, it's an arbitration. It's an agreement by the parties that their dispute will be resolved by a particular panel, in this case, a religious panel, obviously in the Jewish context. But sometimes one sees built into charities' constitutions, particularly in a religious context, that there will effectively, a dispute will be resolved by arbitration by a particular office holder or group of people. One of the advantages is that, like mediation, it's confidential, but it's a bit more, it has a bit more rigor than a mediation process. It's more about somebody deciding who's right and who's wrong, but in a confidential setting. But it's fairly unusual as a way of resolving an internal dispute. And then, of course, we have litigation, which is, as one of the English cases says, should only be authorised in the context of charity when it is the least worst option. I've mentioned the importance already of how you bind in people who are not strictly speaking parties of litigation, so you don't have someone crop up at the end of the case and effectively say, I'm not bound by that judgment. Representation orders are what we're talking about for the lawyers in the room. This particular treatment, litigation, you cannot get without a prescription. You need a prescription from CCNI. It's called permission under Section 54 of the Charities Act 2008. And obviously, again, you need to think about costs. What is this prescription? Section 54 of the Charities Act says that charity proceedings can't go ahead unless you have the permission of the Commission. Charity proceedings is defined in the statute in a really quite hard to understand way. I had a meeting about 3 years ago at which I was the junior lawyer present, and a Silk, who was 20 years my senior, was also advising the client. And the solicitor, who was herself probably 30 years experience as a charity solicitor, said, would an application to rectify this trust deed governing the charity constitute charity proceedings? And immediately I said yes, and Simon Torp, QC as he was then, said no at the same time. And the fact that it is so unclear what is or is not charity proceedings is not helpful. But if you don't have permission for something that constitutes charity proceedings in court, the cases say your claim should be stayed until you get it. What are charity proceedings? Well, some things clearly aren't charity proceedings. Contractual property disputes between the charity on the one hand and someone external, they're not. Employment disputes generally aren't. Arguments about whether something is or is not a charity is not charity proceedings because you don't yet know whether it is a charity at all. Things that clearly are within the definition are claims of breach of trust or breach of duty, schemes to set up a new governing instrument, claims seeking directions. We're the trustees, we're not sure what to do. Dear judge, please would you tell us? Those things clearly are within the scope of charity proceedings. There are a number of ways of avoiding getting permission to bring charity proceedings is quite hard. The regulators don't like, as we've said, charities spending the money on it. There are some workarounds, so hints for the advisors, sort of warnings to the regulator in what follows. There's a line of English cases now from 10 years ago, the Chowdhury case, that you can get an interim injunction if it's urgent before you've gone to the Charity Commission for your permission. This has led to a certain engineering of urgent situations in some cases to try and get off the ground with an injunction before you've gone to the Commission. One can understand why. In a genuine case of extreme urgency, a judge may need to do something to protect the charity before there's been time to go off to the Charity Commission and fill in and give all the information they need and wait for their response. But there is a real risk of abuse here and a real risk of injustice, because I had a case, it was a Goodwarra case in the West Midlands a few years ago. Before I was involved, one side ran off to court for an interim injunction, relying on this line of cases. The other side opposed it. They didn't get resolved on the day, so they came back for a full day's argument later. By the time the judge had decided to grant an injunction to stop the trustees from selling a piece of land, each side had spent £100,000 on the legal costs. And then the problem was, the party who got the injunction and started the proceedings were told, now you have to go to the Commission. They didn't bother, because they got their injunction, they don't care. Now they're just sitting with an injunction with an interim injunction with no proceedings to decide at the end of the day whether it's a good idea for this injunction to remain in force. And the Commission doesn't want to give permission because it says you should be able to sort this out amongst yourselves, you've already wasted a lot of money. So because of this understandable exception for the urgent case, in that case, someone was able to effectively engineer getting something on a temporary basis and then holding on to it by not applying for permission and then applying in a way designed to achieve the answer no, so that their injunction, they effectively got what they want without, on a lower interim threshold without ever having to test it at a trial. There's also an exception for an appeal or a pending cause that usually is taken as if you've got a sort of cross-claim in a claim that's already in existence, you probably won't need to get your permission for charity proceedings, so there's quite a lot of argument about precisely what that means. And sometimes you can avoid, this is a real hint for the litigators in the room, charity proceedings altogether, because the definition of charity proceedings depends upon the court having jurisdiction. And increasingly in England and Wales, and as I understand it to some extent here as well, there are a series of statutory tribunals that hear particular sorts of cases. So you can often engineer your dispute to go into one of those tribunals, in which case you don't need charity permission consent, probably, because it's not charity proceedings, because it's not in the jurisdiction of the court. So most obviously the charity tribunal. So I'm going to look at Francis here. As I understand it, your charity's bill will probably introduce a power similar to our new 280A, power for trustees to change their own terms of their trusts. Is that coming? No, maybe not. I'll give you the example from England and Wales. So we have a relatively recent power for the trustees of unincorporated charities to change effectively any aspect of their trusts, but certain changes, such as the objects, require commission approval. Whereas historically, if you wanted to change the objects of your trust, obviously you had to make a CPRE application, so you'd have to go to court if the commission wouldn't do it, and so you need permission to go to court to change your objects. So a way of avoiding the need for charity proceedings in England and Wales now is to pass your resolution under our new section 280A, go to the commission for approval, and if the commission says no, you challenge the commission in the tribunal where there's no costs consequences, you bear your own costs. You don't need to get the commission's consent to go to the tribunal, and whoever it is who may have been minded to oppose your change will have to try to apply to intervene in the tribunal at their own expense, whereas if it was a CPRE application, they would probably as of right get heard in the High Court and might well even get their costs paid out of the charity if they were not making silly points. So there's sort of quite a lot of tactical skirmishing that can go on here, and obviously cost considerations and other tactical considerations arise, not just the trying to avoid the need to get consent. Same in tax. Sometimes the question whether something, sometimes you can get a point of charity law effectively determined in an argument with the taxman and go to the tax tribunal. Again, don't need charity commission consent. And sometimes in England and Wales, our property chamber of our tribunal system hears appeals against land registration decisions. I'm not sure whether the lands tribunal here does or doesn't. I got conflicting answers from AI when I was trying to work that out yesterday. So maybe someone in the room may be able to enlighten me afterwards. But certainly I've had cases where there's an argument about who the trustees are of a charity. Resolving that question in court would be charity proceedings. You'd need the regulator's consent. You wouldn't get it, at least not for a long time, because they would make you go through all kinds of motions first. But if you effectively apply to rectify the register at the land registry to change the identity of the trustees, and then a dispute arises between the existing registered proprietors and the new ones, that gets referred off to an adjudicator into the tribunal system, and so you can have the argument, which in essence is about who are the trustees of the charity, in the context of an argument about who should be registered as the proprietor of the land, which is not a sort of argument that requires commission consent. So there you go. There are the ways you get round the need to have charity proceedings consent if you really have to. What should happen? It's on the slides, and the guidance is the place to look. Francis mentioned the guidance on the Commission's website. There is a helpful document called Charity Proceedings, a Guide for Charity Trustees. That tells you really what you need to do if you do need to apply for permission to bring charity proceedings. And those are the things the Commission will expect to see. What you can expect in return, at least in my experience, is for the things you tell them to be treated, if you say they are privileged or confidential as such, and generally to be immune from Freedom of Information Act requests, which the people on the other side of the argument will doubtless then make as they try to get hold of your legal opinion to see what the weaknesses in your case are. And the Commission will usually not have any truck with that. But you would expect the Commission normally to engage with the other side. So if you're making complaints if your members making complaints about the trustees, ordinarily the Commission will engage with the trustees and say, it's been brought to our attention, what do you say about this, that and the other? In England and Wales, you wait probably 8 to 10 weeks in a standard case to get an answer for your permission application. I don't know whether it would be quicker or slower here. And in most cases, you get a no or a not yet. And you will get, in England and Wales, a very pious statement about the virtues of mediation and telling you to try it. These are the things that the Commission says, CCNI says it will take into account when considering whether to let you go off to court. Are there alternative ways to resolve the dispute is obviously a big question. Can the underlying problem be resolved by the Commission using its own powers is important because the statute says the Commission must not give permission if it can deal with it itself. This raises the interesting question I had in yet a different good warrant dispute about 18 months ago, where the Commission refused my client's, the charity was not registered, the trustees refused to register it. In fact, our allegations are that one of them said from the pulpit, effectively, we're not recognising any secular authority in this temple. But for 5 years, the Commission had been writing to them, telling them to register they hadn't. And then there were lots of allegations about building work done by the trustees during the lockdown and various allegations about people illegally occupying the charity's premises who were relatives of the trustees without making payments, so on, all the usual stuff. I'm afraid it's usual. Welcome to my life. It's usual for me. Can the Commission resolve it using its own powers? Well, the registration point, we had a slam dunk case. It's obviously a charity. They have failed to register. We're going to win this, Judge. And the Commission said, no, we can deal with this with our powers. And we said, well, you can deal with it, you just haven't dealt with it for 5 years. And in the end, the judge said, well, it was quite Mr. Justice Michael Green. The Commission turned up to oppose our application. They refused us permission. We went to the judge to get permission, and the Commission turned up to oppose our getting permission from the judge. And the judge said, it seems to me, in light of everything I've heard, I have to decide whether the Commission is now, in fact, likely to take any meaningful action. Long pause. Regrettably, it seems to me I cannot be sure of that. Therefore, I have to give permission for this claim to proceed. So it may not be simply whether the Commission can, but whether the Commission will deal with the question. My examples, obviously, are all England and Wales, so I speak freely in this room in expressing views on their performance. Don't worry, they've heard it all before from me. And then questions about the cost and the risk of damage to the charity. The underlying point obviously has to be, though, at the end of the day, the dispute probably needs to be resolved. Sometimes it can be resolved just by stopping everything and separating the groups of people. And let's have 2 charities in future, not 1. That's often a neat solution that avoids having to litigate all of these points. And that was a solution which the Attorney General was very good in England and Wales at effectively imposing on people. The Attorney General is a necessary party to all charity proceedings. England and Wales has increasingly not participated, but historically it was very good at getting involved, saying, stop, we don't need to decide what the trustee means about this and who's the true follower of the relevant doctrine that was laid down in the founding document 200 years ago, or whether this person did that or that. We can just say, let's split the charity's assets and have 2 new charities going forward. That's quite a neat sort of solution. So those are the sorts of things the Commission will look at. If you get permission, the Commission will normally tell the Attorney General because the Attorney is a necessary party. And if you get told no, usually both sides will be advised by the regulator to mediate, and usually most people will. Or you can go off to the court itself to ask for permission, notwithstanding the Commission's refusal. Or you can try and agree with the regulator that, well, can we try the mediation first? And if it doesn't work, can we come back then without having to start all over again at stage 1? A warning to the regulator would be there was a while where in England and Wales, the refusal letter tended to say something like, oh, well, you haven't mediated, so the answer's no. The problem with that sort of response, which although it was sort of convenient and quick to produce, is it enabled you then to go off and have a failed mediation and go straight to the judge within 21 days. So we had a mediation. The only reason they gave for refusing consent was we haven't mediated, we tried it, so can we have permission now? So the regulator probably needs to be a bit more fulsome in their reasons if they've got other reasons for saying no. As I say, if the Commission say no, you go off to court and it's heard by a judge attached to the Chancery division. There's an English case, there are a few cases since this that sort of build on it, but this is the underlying one called Rye, in which the court sets out what the principles are as to whether it should or shouldn't grant permission. And this is the key thing at the bottom. Is the litigation the least worst course? Is there another way of dealing with this? And if not, do we have to do this? And the commission's refusal is part of the evidence, so it's something that the judge gives weight to, but it's not determinative, and it's not an appeal against the commission's decision. It's a fresh decision by a judge. Does he think permission should be granted? Often, because there'll be another side to the intended claim, they will try to, if they get wind of it, will try to get involved in the hearing. The cases say, generally speaking, it's at this stage, it's between the applicants and the commission. The commission will usually just send in a letter of its reasons, won't attend. But you do occasionally get intended defendants in the actual claim you want to bring, trying to turn up and to persuade the judge not to grant you permission. The cases say if they suggest they've got a knockout point, then you can hear it at the permission stage. But what you don't have is a kind of dress rehearsal of the final hearing at the permission stage. And it gets quite complicated because the judge has to have everything you've sent to the commission when the judge is deciding whether to give you permission, and that will include your privileged legal opinions on the strengths and weaknesses of your case. If you're then debating that in the context where the other side then want to be involved, you end up having to sort of devise a system whereby there are sort of confidential bundles that they can't look at, that the judge can look at, which does just make it procedurally more complicated. And those are a sort of summary of the questions the court asks itself. And the court may say yes, it may say yes up to the stage of disclosure or discovery, and let's see if this case looks like it's still got legs once we've got beyond there. And I've never seen this from the commission, but I have seen it from judges in England and Wales. Sometimes they give you permission and they deal with it they're meant to deal with it on paper if they can, and if not, to list a hearing. Sometimes they not only give you permission, but they tell you you've got to issue the claim within 28 days, and they start purporting to give directions about how soon the other side, who probably don't know anything about this yet, have got to respond by, and the things that seem to them to be important to be dealt with at the first directions hearing, and how cost management should work. So sometimes you can get really quite a prescriptive answer from a judge, and that, in my experience, is unhelpful, because if people were not willing to mediate at an earlier stage, and they often aren't, because they say, you're not going to get permission, so I'm not going to talk to you, and we're not going to have a mediation. Once you've got permission from a judge or the commission that you can bring your claim, they tend to take it more seriously. So sometimes being told by the judge that you've got to get going within 21 or 28 days then basically takes away the window you may otherwise have had a meaningful discussion. So I think that is an unhelpful development of sort of judicial activism in this area. The problem is there are so few of them that there's no standardized practice, and every judge is sort of reinventing it for himself every time he or she does one. And usually challenging the grant of permission is a waste of time. If they've got permission, just get over it and deal with the claim, would be the summary. Getting permission is not the only thing, though. Charity decision-making is not always what it ought to be, and if you're going to bring some litigation as a charity, you do want to make sure you have, in fact, taken the decision to bring the claim. A few years ago, there were not charity proceedings because the question was whether certain bodies were charities. A group of NHS foundation trusts in England and Wales brought a claim against all of their local authorities, trying to establish that they were charities, with the consequence that they did not have to pay business rates and could in fact get 6 years worth of business rates repaid. The total value of that claim was in the billions. And it was really it was a claim that had been put together by surveyors who run business rates challenges, who had had a series of golf days for finance directors of NHS Foundation Trust go here and sign up. Very, very few of the actual claimants' boards had considered the question. I was acting for the local authorities. If we made an application to strike out the claim on the basis that they most of the claimants couldn't prove that their board had in fact authorised the bringing of the claim. And it was extraordinary, given we're talking about fairly serious organisations here, how many of them dropped out after that. And it was obviously the question was going to the board for the first time after the master had made the ruling that unless they produced the evidence of the authorisation within 21 days, their claims would be struck out. So making sure the claim is properly authorised is an issue. That's sometimes difficult in charities because there can sometimes be a dispute about who the trustees are, and so you can't work out who's supposed to be authorising the proceedings. The commission can sometimes make an order to make it clear that certain people can have conduct of litigation on behalf of the charity, even if if it's persuaded that the charity has to bring this claim, irrespective of who its true trustees actually are. And sometimes one will want to make protective provision about costs because litigation is expensive. There's a procedure called a Beddoes order where you can persuade a judge separate from the main action that it's necessary to spend the charity's money on these proceedings, and that means that whatever happens at the end of the day, if you're an unincorporated charity, the trustees personally won't be left carrying the can. The charity will have to pay the bill. Or you can sometimes attempt the same thing by seeking advice from the Charity Commission under the power it has under Section 49 of the 2008 Act. But that is, it's difficult to get that sort of advice because usually the Commission is not sufficiently cited of the strengths and weaknesses of the claim to know whether in advance it should say, yes, you should definitely be doing this, and come what may, we will not criticise you for the outcome. How then do you end the treatment if litigation is the treatment? Well, you can always have a mediation at any stage. As I say, gave the example of the one just before the trial. You can fight on and go to judgment, or you can have early neutral evaluation. This, I've only had it once in a charity case, and it worked surprisingly well. There were 2 or 3 sort of real questions in the case, and we just had a half-day hearing in front of a master, so the one below a High Court judge. It's confidential, it's without prejudice, and it's the judge basically saying, okay, on what I've heard so far, here are my views. And in that case, it really worked. It unlocked it. It made it clear that the other side were going to win on issues 1 and 2, but they didn't have much of a chance on issue 3. And that enabled us pretty quickly to do a deal. And the ruling wasn't really a surprise, I think, to the lawyers on either side, but it helped for the clients to hear it from somebody who was respected and independent and said, yeah, yes, no. That's worth bearing in mind. Obviously, you can go all the way to judgment. Judgment is almost invariably going to be a public ruling. That can be embarrassing, can be awkward. It tends to result, the exceptions, but tends to result in a sort of winner-takes-all type of answer, which can make it hard for people to live together afterwards. It's very rarely actually the end of the road. There's usually some further step that needs to be taken. Another meeting has to be held, a new election has to take place, the constitution has to be amended. So it doesn't always bring the finality you might think. And as I say, people have to work together subsequently. So it's not perfect. It's the least worst, as we said. Paying for the treatment, well, I've mentioned Beddoes in Section 49. Increasingly in England and Wales, we have procedural provision for cost capping orders. So I've had one charity case where the other side didn't have much money. They made at the very beginning an application to cap the costs that anyone could spend on the argument to try and make sure they stayed proportionate and that they effectively weren't bullied out financially of the dispute. But there is the cost of the Attorney General where involved will always be paid by the charity, and that has to be factored in when you're thinking about the costs. And there's a case called Rebuckton that talks about situations in which if the litigation was brought about not through somebody's fault, because there was an ambiguity in the trustee, because something's happened that wasn't expected, often the rule will be that the costs of all parties will come out of the trust fund, and that can be significant. Finally, a couple of minutes, prevention. Obviously, a lot of these things are about personalities and they are about relationships, so time spent with people perhaps outside of the boardroom in advance of board meetings at which contentious items are coming up, or members' meetings, is obviously time well spent that might head off a showdown in a more formal context, in which people's views get embedded, not least because they've made public statements, and the questions of losing face arise if you seem to backtrack. But in terms of sort of things that lawyers and trustees might think about around those sort of more human aspects of it, having a code of conduct for trustees, and even better for members, is really helpful so that people know what's expected of them in advance, and training on that and perhaps on a conflict of interest policy helps people know in advance and helps them start to think about what the issues are and perhaps recognise, oh, actually, yes, I do have a conflict. I didn't never thought about it, but because I've been appointed by, I'm also a trustee of this group, actually, I technically do have a conflict of loyalties when we come to discuss this item. A thing that's very often missing from constitutions is a power to remove trustees, and it's very rare to see a power to suspend trustees. It would be really good if people have that. I've seen cases in which there have been probably weaponized safeguarding allegations against a trustee, but in the context of an independent school, which was a charity, and there was no power to suspend the trustee. And the person concerned insisted on continuing to come to the meetings, which tended to be held at the school. despite the fact there were extant safeguarding allegations, and they tried purported to suspend the person, and the person challenged it in court, and it was settled, but it cost a fortune. So a power to suspend and remove trustees and members would be valuable, particularly while disputes are sorted out. And most modern constitutions, certainly the Charitable Incorporated Organisation Constitution, CIO Constitution, will now usually have some sort of alternative dispute resolution process embedded in it that says that if there's a dispute between the members, it has to follow this kind of process, has to be mediation or ADR before anybody goes off to court. So that's a helpful safeguard as well. You could build it into a code of conduct. Effectively, you're trying to create a contract by which your members and trustees agree not to pursue litigation unless they have first tried some other sort of remedy. And I think at 12:05, I ought to stop there.